Now, we proceed to our next panel. Moderating is Ms. Cheng Liling, who leads the Financial Institutions and Technology Industry Group and Financial Services Regulatory Practice of RHT Law. Joining Liling are Ms. Sylvette Tangyang, Senior Partner at Villaraza & Angko, Mr. Ian Lim, Director for Private Wealth at the Visitor Singapore, and Mr. Pang Tiwi, Director at RHT DigiCapital.
Good morning, everyone. Welcome back from the break. When we think about estate planning and trust, we are likely to immediately think of more traditional assets such as real property, collections of books, artwork, wine, cars, and investments in stocks and shares, monies in bank accounts. Technological changes have indeed transformed many aspects of our world and our lives, including the nature of things that we buy and own. Think digital music, digital art, digital books, and digital currencies. The nature of digital assets that have no physical substance requires us to change the ways in which we think about how we hold, grow, and transfer our assets. Today, we address the issue of how individuals should plan for and manage their digital assets during their own lifetime and for their estates. With regard to cryptocurrencies, the courts in Singapore, in the landmark case of Coin versus B2C2, acknowledged that cryptocurrencies may be treated as property and hence could be the subject matter of a trust. Across the world, courts from South Korea to certain states in the US, including certain tribunals in China, have also recognized cryptocurrencies as property. The proliferation of digital assets, the minting of not just coins, but also multi-millionaires, the increased investments and transactions in digital assets have also required tax authorities to consider the tax treatment of such assets. It is necessary, hence, to consider the tax implications of buying, owning, and selling or transferring different types of digital assets, whether they are a form of securities, commodity, a payment token, or something else. In the area of investments, traditionally, business owners and investors are familiar with the use of corporate structures like a private company or a public limited company as vehicle to raise capital, to make profits, and to distribute dividends. The company structure sees a board of directors managing the operations of a company and shareholders who hold the board to account and have rights of voting and attendance at meetings by virtue of their shareholdings. The digital evolution, though, has seen the growth of new structures such as DAOs, decentralized autonomous organizations, which change the traditional corporate structure as we know it. DAOs are decentralized, i.e., they are not governed by any one person or entity, and the governance of a DAO is coded into smart contracts, and members make their voices heard, so to speak, by staking their digital tokens and voting in the digital community. The legal, regulatory, financial, and tax treatment of different digital assets differ depending on their nature. And on a practical level, individuals also need to think about the real issues of safeguarding these assets, even the passwords to access these assets, and passing them on to future generations. Today, we're really pleased to have on this panel a professional trustee, Ian, a fintech investment manager, Tiwi, and a senior tax lawyer, Sylvette, to share with us their perspectives and guidance on how to manage digital assets. So, Ian, thank you for joining us today.
Thank you, Liling.
So from an industry and trustee perspective, could you just share with us, Singapore trustees are seeing increasing demand in digital assets being held under trust. So what are some of the drivers behind this trend?
Sure, I can answer that. As a professional trust company in Singapore, we have seen a surge in clients looking to put their digital assets under trust. There are a couple of reasons for, I think, this trend. The first is probably the emergence of digital assets, including cryptocurrencies, as part of their wealth management and asset management portfolio in Singapore. So in the past decade, we've seen other asset classes emerge as well. For example, private equity, hedge funds, VC, venture capital funds, real estate funds. These assets have been, developing in Singapore because of the support of the local Singapore financial ecosystem. So fund managers specializing in these type of asset classes have now brought this, forward. And with digital assets, we also have more service providers moving to Singapore. Singapore is one of the countries in the world where, ecosystem, the digital asset ecosystem is developing. So I think this is one of the drivers. The second driver is probably the coming to age of the next generation or second generation of investors in Asia. So, for example, family members, second generation, third generation family members of wealthy families moving to Singapore, setting up their single family office and using digital assets as part of their asset allocation strategy. And these younger investors, they are starting to come out and have a louder voice in the way the family assets are invested. And also, a lot of them are more, more liberal, more Western educated in their investment strategies. And then also there's proper governance frameworks in their investment strategies. So digital assets, I think, are here to stay as part of the wealthy families' overall asset portfolio.
Okay, thanks, Ian. So, in your role as a trustee, there are different types of trusts, as we had discussed. What are the key differences in the role of a trustee of, say, a family trust, i.e. a settlor settling of assets for estate planning, compared to a trustee of an asset protection trust where the settlor perhaps wishes to ring fence his assets from different types of risks?
Okay, thank you, Lili. So I think when we typically talk with families, the starting position is that they want to set up a trust for avoidance of probate, succession planning. If you ask me, is Singapore an asset protection jurisdiction? I would say no, because Singapore has not enacted a specific legislation to curb, or to have a statutory limit for creditors to claw back assets from the insolvent. So, for example, if we draw comparison between Singapore and, let's say, Bahamas, which has a 1 year clawback period, and the Cook Islands, which is a 1 year clawback period, I think families here they don't specifically ask for asset protection as one of the objectives of the trust, but more of a side benefit when they do their private family trust structuring. Singapore, I think, as a jurisdiction, MAS often gets accolades for developing Singapore as a wealth management jurisdiction, but I think the lawmakers here, and the legal community, they've also contributed greatly to Singapore as a wealth management jurisdiction. So, for example, in 1994, I think Singapore announced that it would depart from the English common law system and start its own journey down developing law. So I think with asset protection trust, when I sit down with family and they tell me that this is probably one of their considerations for asset protection, but not the main factor. Something they can do to bulletproof or strengthen the asset protection would be to have the settlor not reserve too many powers. He should not be a beneficiary of the trust. In the trust deed, he should not reserve too many powers. It is generally accepted that a settlor may reserve investment powers when he sets up the trust. But if he really wants to make the trust more robust, then perhaps he can consider, not having that power. And then if he doesn't have that power, then the trustees have the responsibility to appoint an investment manager to manage the assets, because trustees are not investment specialists.
Okay. So at this point, I'd like to invite the audience, please, to keep your questions coming. I know in the audience there may be holders of digital assets, considering how you intend to hold these assets and plan for future generations. So Ian is here to really answer your questions on how you can structure your family trust and so on. So Ian, given the proliferation and the growth of digital assets, right, what are some of the key digital assets that have been subject to trust that Vistra has established in recent times? And do highlight for us as well, what are some of the issues and considerations that settlers should be mindful of?
Sure. Okay, for digital assets, really, Vistra, what we've seen is really, just cryptocurrencies, which is not, all digital assets are all about. There are other types of digital assets, as Tiwi will elaborate later. So for Vistra, most of our bank accounts to hold investments are held with private banks in Singapore and Hong Kong. Some of the banks, they do have a cryptocurrency offering. So basically, if you have a trust overlaying the bank account, then the digital asset will enjoy, the benefits of a trust, like avoidance of probate, succession planning, and ring fencing of assets from creditors, as you would for traditional assets.
Okay.
Some of the considerations when clients look at putting digital assets under a trust is whether the trustee will actually transfer the cryptocurrency to the beneficiaries in future. There's a lot of factors affecting this consideration because, for example, some banks, they only allow clients to transfer in fiat currency and transfer out fiat currency because of the Financial Action Task Force rules on transfers of cryptocurrency. They may not allow transfers of cryptocurrency. And similarly, trustees like ourselves, in future, when we make a distribution to a beneficiary, we may only transfer fiat currency. And then clients should also look at the terms and conditions of service providers who offer digital assets, because one of the questions will be, what are some of the risks and how service providers indemnify themselves when acting as custodian of these digital assets.
So when we talk about digital assets like digital currencies, where the value fluctuates and there's great volatility, how as a trustee or an investment manager that's managing the trust mitigate these types of risk, and how as a trustee would you, in a way, be very clear to the settlor where the investment risks are, so that the value of the trust assets are actually, in a way, preserved?
Sure.
Yeah.
In Asia, where most of our clients are from, the clients, when they set up a trust structure with us, they want to reserve the power of investments. They want to be in the driver's seat. They want to control the investments. And in our trust deeds, when we set up a trust, we also have indemnities that absolve us from interfering in the investment management of the trust assets. So really, it would be the client and or his appointees, family members that manage the trust assets. The reserve power trust is commonly used in many jurisdictions, and Singapore has had it in place for a long time.
Okay. And moving on to, say, the asset protection trust, right, where by law, I think evidentially it needs to be very clear that the settlor has relinquished control over the assets. How would these digital assets, then the risk of or the need to preserve and to grow its value, how would this issue be managed?
That responsibility actually really rests with the client. I think in Singapore, going back to Singapore, whether it's an asset protection jurisdiction, I think the starting position is that the client must be solvent, and when he gives the assets to the trust company, when he sets up the trust, it must not make him insolvent. And then in Singapore, we have the IRDA, or the Insolvency Restructuring Dissolution Act, which has a clawback period of 3 years for gifts at an undervalue, and 2-year clawback period for gifts for unfair preferences. So It is possible to achieve ring fencing asset protection benefits with a trust. It's just that that's usually not the main focus of the client when setting up a trust with us.
Okay, thanks. So at this point again, just to inform our audience that I'll later be posing some questions to Tiwi. Tiwi himself is a savvy fintech investor, and he would share his perspectives as well on the risk and rewards of holding different types of digital assets. So do keep your questions coming. Ian, so when we think about assets, when we think about trust, we always think about tax, right? So what are the different tax implications of holding digital assets, and what considerations should digital assets owners have when structuring their digital asset holdings?
Thanks, Celine. Singapore has become a very successful wealth management jurisdiction because we do not have capital gains tax in Singapore. We have dividend tax at source, but dividends paid to shareholders, is not taxed. And then interest income is also not taxed in Singapore. And then there's also very generous concessions made by the Inland Revenue of Singapore for foreign trusts set up in Singapore, locally administered trusts in Singapore, and you have all your 13U concessions, tax concessions that the first panel discussed. So I think it's important to remember that these designated investments under all these Section 13 designated investments list doesn't cover direct holdings of digital assets such as cryptocurrency. However, as part of the local investments that constitutes a family office investment fund assets, it could constitute crypto funds set up in Singapore by a fund management company or bank. So these would count as local investments. And of course, you have all your derivative structured products offered by wealth management financial institutions in Singapore that could possibly fall under the designated investments list.
Okay. And in terms of setting up onshore and offshore trusts, I think one of the key issues that settlers might need to consider would be where is the mind and control for tax purposes. Would you share your views on this?
Yes, I think that's really the thing we need to look at. So where are the investment decisions made? If for example, if the investor or the client holds a full-time job, he's a lawyer, doctor, accountant, and then he just invests, when he has time, that may not have tax implications in Singapore. If you contrast this with someone who is sitting at home all the time, he does not have a full-time job. He's got all these trading terminals in front of his desk, and he makes a lot of investment income. If he's based in Singapore, then the tax authorities in Singapore might consider that is his job, and therefore the investment income that is actually the trading income that he makes is actually potentially taxable in Singapore.
Okay, thank you. At this point, note to audience as well that on our panel today we have Sylvette, who is a very senior tax practitioner. So I'll be posing some questions to Sylvette as well on tax treatment of digital assets. Please feel free to put up your questions as well. Moving on to Tiwi. Tiwi, so keen to hear your thoughts and perspective, because I know you manage your family wealth, and you come from a investment background. What are some of the recent trends and hot topics that you see in the digital asset ecosystem of late?
Right. Thank you, Lily, for the questions. Yes, I can definitely answer that. Recently, we have seen, like what Ian mentioned just now, we have seen the family officers and also even corporates passing on their wealth to the next generation. So as a result, the private banks, even and also institutional investors are also demanding and looking into different classes of assets. So these classes of assets with ranges from whiskey funds, wine funds, and also ETF, alternative classes of ETFs, like for example crypto ETFs and the likes of it. So we see a big drastic change in those area, and we also see that there are for the younger generation, investors tend to like to mix in a bit of lifestyle and fun together with the investments. So as a result, there are more and more focus on this sort of alternative classes of assets. But having said that, of course, when we talk about new types of hot topics, we cannot ignore the latest trend over the last few years, which is crypto and NFTs, and also, of course, the blockchains. So what's interesting is we come to learn that blockchain has fundamentally given investors or traders who does not know each other the ability to trust each other and to also to carry out transactions online. And also crypto became one of the biggest way to make payment on these blockchains. And also, of course, the NFTs suddenly became the assets for people to buy, because NFTs allow investors to look in to own assets digitally, which is not the very common aspect, even as recent as a couple of years ago. So because of the changes in demand and also the type of investments, investors are also the considerations that investors take are also changing. Like, for example, nowadays we see a lot more focus looking into cybersecurity, looking into other, like, for example, when you buy NFTs, you have to consider the liquidity of NFTs and also volatility of cryptos. People are getting used to the new way of investing, although it's still not the main way, but we definitely see it coming. And like what Ian mentioned just now, we believe digital assets is not to be ignored and is here to stay.
Thank you, TV. Just drilling down a little bit on some of the points that you made. Would you just elaborate for the benefit of the audience what you meant in terms of cybersecurity, considering the liquidity of NFTs and the volatility of cryptos?
Yep, certainly. So, with regards to cybersecurity, we the fundamental basic, of course, are the ways that people look into to make sure that their digital wallets are safe. Like, for example, there are more and more methods to look into all this. Like, for example, using two-factor authentication rather than a single password, or via just email or text messages. People are moving on to like methods such as Google authenticators to securitize their digital wallets. So investors in general are becoming more sophisticated and more mindful of how cybersecurity could ultimately affect or create a negative impact to their investments in the long run. With regards to NFT liquidity, when we look at NFTs, because NFTs by definition is unique on its own. Every NFT is unique on its own. So as a result, the value of the NFT is only as good as the next person who is willing to pay for it. So the liquidity of the entire group of NFTs together with the interest in the NFTs are very important, rather than just looking at the digital art or the physical asset that's tagged to it. So these are some of the considerations that we see investors are becoming more mindful and also looking more into it as well. And
yeah. So when it comes to NFTs, we've read about different types of risk, like rug pull scams, and the need to actually examine and do our own due diligence on the development team. Would you please drill down a little bit into more detail for these two aspects?
Certainly.
Yeah.
So rug pulls, broadly speaking, are just are scams. So rug pulls can broadly be categorized into two variants. The first one is hard rug pulls, and the second one is soft rug pull. So hard rug pulls are mainly revolves around crypto assets, especially on the cryptocurrency points, whereby the programmers or the founders of this particular coin are out to scam investors right at the beginning. The way they do it is one common way is they put in hard codes into the digital assets to allow themselves or the people that they work with to sell their coins or NFTs, but not the buyers. So as a result, you can buy in these crypto and these digital assets, but you will have difficulty or inability to sell them. For example, they may allow you to sell it, but half the time, or a lot of the times, you may find it difficult to offload your entire portfolio because of the codes that are in there. Other examples of another hard rock pool is liquidity stealing. So when they deal with when coins are introduced, they're introduced together with the liquidity pool. So developers of this who are out to do a hard rock pool, what they do is they will maintain the liquidity pool for a while, and then once they have achieved the target that they want, they'll take away all liquidity and immediately rendering the coins that they introduced to be worthless. So these are examples of hard rock pools. Soft rock pools, on the other hand, are less unethical, and but it's less damaging in a way to investors. So soft rock pools include, like, for example, a developing team, they agree before minting the NFTs that they will donate a certain of the proceeds to charity, for example, to increase interest within the communities. But after they get the money, sometimes they don't deliver the promises that they do, that they promise right at the beginning. And also, another example is they will come out with roadmaps or futures of these NFT projects, and they fail to deliver, or half the time they drag their feet on it. So these are soft rock pool. So the main differentiating factor between hard rock pool and soft rock pool is that hard rock pool are illegal. They are criminal offenses. But while soft rock pool are mainly unethical, they may or may not be criminal or illegal per se.
Yes, so in terms of the very important acronym DYOR, do your own research, how would potential asset owners and investment managers be aware of this risk and mitigate these risks?
Yes, so before I answer the question, let me introduce two friends to you. Both 4 letters. The first one is FOMO, FOMO, fear of missing out. This is your enemy. The second letter is what Lily mentioned just now, DYOR, that is your friend. So FOMO, a lot of investors I've come across, they invest or rush into investing NFT projects or even ICOs or cryptos, digital coins, because of their fear of missing out of the next big wave coming. But as a result, I've come to notice that majority of people who rushes into it tends to lose quite a fair bit of their investments because they don't really know what they are investing into, or they don't understand the project entirely. So as a result, they fail to recognize the danger and the risk. So as a result, that's where my point comes in, where FOMO is actually your enemy. FOMO comes in, it could be an interesting point for you to to try to understand a bit some of the digital assets or NFT projects, but don't let it affect your investment mindset. After all, when you put money into all these digital assets, these are real investments and they can be worth quite a fair bit of wealth that you're putting in. So FOMO is definitely not your friend. So you have to be careful when you have that mindset of fear of missing out. But whereas for your DYOR, or do your own research, that is definitely your friend, because that basically you need to, as per any investments, it is always good to know what you are investing into. Like, for example, especially in terms of the digital assets in the blockchain space. Reason for that is because of the lack of regulations around the world right now. So as there are when things are not so well regulated, there are a lot of scams, a lot of rug pulls going through, and hence it is even more important for us to understand what we are investing into, and also to and hence to do your own research. For example, before you go into an NFT project, it might be a good idea to understand who are the founders behind the NFT projects. Are they docs or are they undocs? Meaning that did they reveal themselves, who they are in real life, their names, their job, their history, whether they have got anything or has carried out any NFT projects in the past. So there are track records. These are important things that we should consider. Like, to put things in perspective, if you invest into, for example, an IPO, wouldn't you want to know who is the management team? What are their experience? Would you trust somebody hiding behind a pseudonym or a digital wallet? If you wouldn't do that in real life, then why would you do it on the digital space where it is even less regulated than the traditional financial markets? And hence, other important points, like for example, the development teams, because are also very important, because when you develop, for example, an NFT project, when you run an NFT project, there are actually a lot of work that needs to be done. So it is important to understand who are the people behind it, who is the team behind it, and is it just two young kids in a garage in a far away land, or is it professional teams who know what they're doing in terms of designing, developing, laying out the roadmaps and delivering the roadmaps? So all these are very important. And the last point I would like to highlight is also the roadmap of the NFT project, for example, is also very important, because roadmaps to me is like the IPO prospectus. When you read the roadmap, you understand where the community or where the founders want you to go, or where they are leading this project to. So once again, if you don't believe in IPO prospectus in a real financial world, why would you believe in a fluffy roadmap? So sometimes it is good to understand a bit more about the roadmaps. And but the beauty of digital assets or NFT project these days is they are widely marketed, and you can get access to direct conversation with the founders through platforms like, for example, Twitter's, Instagram's, Discord. Discord is something that is very common in NFT. So it will be good to familiarize yourself with all these tools on your hand, the platforms and the community. Ask them any questions and see how they respond to it. If you think their response is not good enough, then probably the project is not for you.
Thank you, Kiwi. Just one follow-on question. Not sure if it's this thing about rug pull scams that you've mentioned, and how certain bugs in a way are encoded into the program, which lay persons might not be aware of. How do we avoid falling victim to a rug pull scam?
That's a very good question. So one of the way, it's true that most of us will not be able to recognize the coding behind the smart contracts or in the tokens. So one good way is to, especially for crypto currencies, one good way is to buy just a little bit and then you try to sell it. If you can sell it, then probably the odds of it being a liquidity scam or rug pull will be lower, versus if you, for example, if you buy $100 worth or $10 worth of coins and you realize you can't sell it, then I would say avoid the coin at all means. So don't believe in anything that people tell you. So do a little bit of test, take baby steps into buying rather than jumping in with your net worth to do that. When you invest, especially in new coins. And another thing that I would comment about is it may be good, because at the end of the day, NFTs, cryptos, and digital assets are still in their infant stage. So as a result, regulatory are constantly changing, and also we are still learning as we go along. So it might be a good idea to just allocate something that you're able to lose rather than put in a bulk of your wealth into these sort of assets, because as of today, these classes of assets are still classified to be relatively high risk. So we would recommend maybe 5% of your entire worth to go into this class of assets. May not be a bad idea, rather than putting too much. And sometimes, as one of my very well-to-do and also very knowledgeable friend always tell me, if you lose sleep over a certain investment, you probably have overinvested. So you might want to pull back a little bit on that.
Okay. Thank you, Ian. Thank you, Tiwi. So we've heard from Ian, professional trustee, Tiwi, fintech investor, and now really like to spend some time with Sylvette. Sylvette is a seasoned tax practitioner, and I think as asset owners, tax treatment of the assets we own, tax treatment of the things that we do is not something that we can easily run away from. So, Sylvette, do please share with us your views on what are some key tax considerations that digital asset owners have to bear in mind with regard to different types of digital assets.
Okay. Currently here in the Philippines, there are hardly any, if not, I could say no rules regarding taxation of digital assets. The only rules or regulations that we have are in connection with the central bank having issued regulations which will govern the trading of digital assets through a digital exchange. So that is the only thing that is of relevance with respect to digital assets. The Securities and Exchange Commission, under which uh, digital asset may be classified or fall under a security, has passed allegedly draft rules, but when regarding digital assets, but when we asked for a copy, they still said it's a work in progress. So the situation here really in the Philippines is that trading, selling, exchanging of digital assets is under the tax authorities' radar. Actually, we can apply if you are prudent and you want to have cover, you can actually pay for taxes, income tax, for example, and VAT, value added tax, in relation to the transfer or sale of digital assets. However, since digital assets are done online or not in concrete form, there's a way that the Bureau of Internal Revenue will have no knowledge or no way to track down the trading of digital assets. So that's where we are right now.
Okay. So I think when it comes to tax treatment, back to basics would be how we classify the digital asset. If it's if it's a form of securities, for example, then we do need to consider if it's capital gains. If there's a pattern of trading, then whether it is income in nature and subject to
Correct.
income tax treatment. So we always
Yeah.
try to apply basic principles to this evolving and new asset class. The part
You're
about
right about that.
yeah.
You're right about that. The thing is, since there is no record, then those who are more avant-garde and non-fearing would rather not pay taxes due. In essence, there are really taxes due because you are selling an asset, and selling an asset where there is gain will be subject to tax either as an ordinary asset or a capital asset. So yes,
Okay, so that proof of transaction is where evidentially there may be some difficulty for tax authorities to track and so on.
yes,
Mm.
there's no reporting, there's no document, you can't trace it. So
Mm.
that's where it is right now. I also don't know. I asked Bureau of Internal Revenue officer if there has been any filing and payment of capital gains tax and documentary stamp tax in connection with virtual assets, and they're not even really aware that these are in existence and how they are traded and exchanged, and that the gain realized from the sale of the asset would be taxable under the general rules on income tax.
Okay. And Sylvette, just share with us as well your perspectives and views. So for jurisdictions that still have estate or inheritance tax, obviously, on the passing of the settlor, perhaps then the estate needs to be valued. And if, let's say, the estate were to comprise, if digital assets were to comprise a substantial part of that estate,
Yes.
how might tax authorities look at how the estate is valued, the digital
Okay.
assets is valued?
Yeah, if the decedent's family decide to declare the digital assets, the valuation will be as follows. For cryptocurrency, it will be the fair market value, which is the average, the highest and the lowest price for that asset, cryptocurrency, nearest the date of the decedent. But this is also, as I said, it's a difficult thing. How would you know what is the value of the cryptocurrency for purposes of paying the estate tax when there's no registry wherein it could be recorded. So what's your basis? The rule is fair market value at the time of death. So that's one. For non-fungible tokens, this is akin again to personal property. So when you die and you're holding these digital assets, which are non-fungible tokens, it would be a 6% estate tax or 6% donor's tax. Now, for security tokens, there are two categories. I don't know if it's in you implement this in Singapore, but there is security tokens which are listed and security tokens which are non-listed. When it's security tokens which are listed, they're traded through an exchange. It's very easy to get the value of the of the of the NFT, non-fungible tokens. For non-listed tokens, FMB shall be the book value of the coin tokens based on the audited financial statements of the issuer.
Okay, thanks, Sylvette. Just
By the
drilling.
way, I would like to mention that while there are no rules for digital assets in our Securities and Exchange Commission, they have just drafts. The Bangko Sentral ng Filipinas, the central bank, has given out rules on relating to digital asset exchanges. It's just the trading that it's the main trading, not just the owning and selling, but the trading of digital assets through the exchange.
Okay. And drilling a little bit into the crypto ecosystem, we know of activities like crypto mining and staking activities to generate returns for the token holders. So these are activities resulting in the miners and the stakers, for example, receiving new coins. Can these be considered income generating events, and what might be the tax impact of such activities?
Definitely, they are. When one is mining or staking, there's a cost that is incurred in doing that procedure, mining or staking. So what if the person who is doing the mining or staking sells the cryptocurrency or Bitcoin to another person at a gain? Let's say the selling price less the acquisition cost will be under the general rules of income taxation in the Philippines, will be subject to taxes. So now the tax rates depend the sale of the cryptocurrency resulting in a gain. The gain will be subject to tax depending on the taxpayer. If it is an income tax and it is a capital gain, then it would be, well, there are two instances, sorry. One is a person is engaged in the trading of cryptocurrency as a business. In this case, the tax on that for tax purposes, that asset will be treated as an ordinary asset and will be subject to ordinary income tax. If the sale is by a corporation, the range of the corporation's tax will be 20 to 25%. However, if it is a capital gains tax as versus an ordinary income tax, the tax would be 15% if it is 15% of the net gain.
All right.
And then if you are, just to flag, if you are in the business of trading, buying and selling cryptocurrency, that is subject to value added tax of 12%.
Indeed, yes. So indeed, these are really key issues that token issuers, asset owners have to bear in mind. VAT in Singapore, GST, do come speak to your tax advisors, because these are very real issues. And I'd like to pose the next question really to Sylvette and to Ian, the practical aspects of this topic that we're talking about. How would one holding on to digital assets integrate it into one's estate plan? What are the steps that a normal person like me holding on to, say, digital art or certain cryptocurrencies, what should I be doing to secure my assets for future generations in my estate plan?
Okay, shall I answer it first? Okay,
Yes.
thank you, Ian. The first thing that you should do if you are preparing for your estate planning and you have digital assets, as I said before, there's no regulation, no registry. Right now, what you can do is already distribute to your heirs, compulsory heirs, your digital assets. But if you prefer to hold on to your digital assets until you pass away, then what's important is to make an inventory of the digital assets, list down the code required or the key to open the asset, and you have to already indicate how you plan to distribute the digital assets. As a decedent has the right to distribute his assets in the estate to the extent that it does not impinge upon the legitime of any heir. The legitime is that portion of the estate which the government, which by law, must go to each of the compulsory heir, like children and spouse. They share equally, assuming there are no other heirs, just the children's spouse. They share equally in the estate of the decedent. So that's how it's done. And then, well, the last step would be to arrange for the transmission of the keys. I guess the point is to really make a list. What are your digital assets? What's the key or code password that to access that? And because this is something that is really done digitally, it's really possible. And I think the Bureau of Internal Revenue of the Philippines has sort of been blindsided on this type of asset. They have not really, as I said, the Bureau of Internal Revenue officer that I spoke with said that he doesn't see any, in his estate tax settlement, he doesn't see any submission of digital assets as part of the asset of the decedent. So that's it.
Yes. So practically speaking, be very intentional to list out what are the assets that one owns. Importantly, then to plan the allocation as you've mentioned, and legalize it, put it in some form of a document or your will as to how you intend for it to be transferred after death, and make sure that people have access to those digital assets in the form of the keys. So of course the keys are a series of numbers and hashes, and the security then would be, how do you secure this private key to make sure that it doesn't fall into the wrong hands or someone accesses it at the wrong time and depletes the wallet, so to speak. So would you be able to share your views, Sylvette?
Yeah, I have a client, high net wealth client, who does have a considerable amount of digital assets. He had a will. The will didn't mention the digital asset, but he had the schedule of the digital assets, the access asset that will as an access document, which is either the key or the password. And then he told his children, this is it. This is how it's divided. And it was not included in his estate tax return.
Okay.
So that's, okay.
Okay.
I know.
Yeah. All right. Ian, would you like to?
I think
Yeah.
Sylvette covered all the bases. Just maybe one point. So Singapore abolished estate tax in 2008. So we don't have to go through the estate tax
Wow.
calculations.
Good.
But yeah. I think Sylvette's got it all.
Mm.
Speak to your usual contact at RHT Law to get your Singapore will done, and make sure that they attach the schedule of digital assets along with it.
Yeah.
Thank you. That's correct. I have actually a foreigner who has residence in Singapore and the U.S. Maybe I can definitely I'll refer Chi Liling to that person because he needs to have the Singapore legal jurisdiction.
Yeah. I was really keen to explore really the practical real life difficulties or challenges on how you actually keep and secure that password, because that is really your digital key to your assets.
Yeah.
There was a recent case we acted for a company where the representative, the employee of the company, when he updated certain program in different computers, he inadvertently lost the seed phrase or the private key to the company's e-wallet that contained over $1 million worth of cryptocurrencies. So everyone knows that when you lose your private key, that's it. And you read about news about some guy in Europe who's traveling the land to try and find his hard disk because he just threw it away in some wasteland, and that hard disk actually contained his private key to access his digital assets, which is now worth a lot of money. We've also read about CFOs, CTOs who were the sole person to hold on to the digital key, and they suddenly pass away and no one knows where that key is.
Yes.
So I think advisors like us have to bring our clients intentionally through the practical steps on how you secure that key, first of all, and make sure that that key is accessible when your estate is ready for distribution. There's talk about how you can split up the keys, but then again, you want to make sure that you always have to bear in mind and update your will and your letter of wishes or your directions, because things can change over time, right? People with access to parts of your private key may not always be around, or you may lose trust in them. So how you split up those keys, who has access to it, who has the backup copies and all that would be things that you need to think through. So I think we've got lots to cover actually in this topic. I think it would be really good if we started to address some of the audience questions. We have a couple of minutes. So one of the questions would be, for crypto assets that the principal wants to be held for long term, what is recommended to ensure that they are held for decades and not sold and distributed when the principal passes away? I think this is a question for Ian.
Yep, sure. Sounds like it's a trust-related question. When we set up a trust, we have the client or the principal or the settlor complete an investment risk profile questionnaire for the client. So if indeed the principal wants to state that 10% of the overall trust fund should be held in cryptocurrency for long term, Singapore trust go on for 100 years. So let's say crypto to be held for 50 years. During the annual trust fund investment portfolio review, we will ensure, the proper check and balances that the appointed investment manager has indeed kept, whatever percentage of the portfolio in cryptocurrencies.
So this would be instructions to the trustee.
Yes,
Yeah.
it will be a prescribed investment direction letter from the client to the trustee.
Okay. Some crypto assets, like some NFTs, the owner owns the IP. If liquidate, valuable IP is lost too. How can IP assets be protected in the context of a trust? So this question is actually quite deep, and there are actually a few layers to it. So as Tiwi had mentioned, it's very important to be very clear what exactly you are owning. when you talk about an NFT, a non-fungible token, is it a digital certificate of an underlying asset? Is it a license of something of the underlying asset? Or is it a fractionalized token that represents a fraction of ownership in some underlying asset? So it really depends on the nature of the NFT. So if you can understand or analyze what is the nature of an NFT, then you know how to discuss how you protect the property rights that are embedded in that token. So for example, a digital an NFT of a digital art, for example, or NFT of an art piece, sometimes it's you don't own the copyright. The creator of the art piece continues to own the IP, and all you have is just a license. So it's important to read the terms and conditions carefully for the different NFTs. I hope this answers your question. How is insurance cover developing for digital asset risk? I think right now it's still very, very expensive when it comes to cybersecurity risk.
If I may be able to add on a little bit
Yes.
on that, from my understanding, even as professional indemnity rights, insurance companies these days, when they hear of the word blockchain, they either don't cover you or they charge very, very high premiums. So if going down one more level, which is the question here, the insurance coverage for digital asset and risk, I would think that part is still in development right now. There isn't a clear sign of or a clear flow of process on how they can or cannot cover. So I think this one would be best to speak with the insurance agents
Yes.
from the respective companies, as every insurance companies have their own policies on that, and how much is covered or not covered is also depending on how how well you keep it. For example, if you lose your own password, I don't think the company is going to do a payout for that.
Right. Okay. The relinquishing of crypto assets to the trust by the settlor only sounds useful for long-term assets. For crypto assets, the principal is still actively managing. Is it the will and or a testamentary trust that should be used to manage the crypto assets after the principal passes away?
Sure, I can take this then.
Yeah.
So I think this question has two parts. The trust, as we discussed earlier, is not just for long-term assets. It's also for avoidance of probate, asset protection, and smooth succession planning to the next generation. If it is indeed the client's wish that he wants to have the flexibility to manage the assets actively, then sure, he can have a will or trust to say that these digital assets will go to the next generation after principal passes away. But he just needs to remember that those assets still need to go through the probate process. They will still be subject to any creditor claims, and this will not help families that are trying to avoid any infighting or family conflict between siblings that are fighting over the family's assets.
Yeah. So I'm not sure if we've answered the question. The will takes effect upon death. So while the principal is still alive, certainly he can continue to actively manage it. And the will that takes effect after his passing, and the testament, the trust that takes effect thereafter, would indeed be the modules that will be used to manage the assets after he passes on. Yeah.
So I think the executor of the client's estate needs to be very savvy when it comes to digital assets as well, to know which jurisdiction, which service provider to go and claim those assets to pass it on to the beneficiaries.
Yes, indeed. So it's actually very incumbent on the principal to really leave detailed directions and instructions as to how to access these assets. Where are the keys? Yeah. Okay. Would an NFT based on landed properties in Singapore be seen as land sales and subject to stamp duties like normal land sales? if I assign rental income and sales proceed to a trust, which in turn issue NFTs to investors, is this legal in Singapore? Wow. Yes, okay, if you wish.
Yeah, maybe I can try to take this question. So with the NFT based on landed property in Singapore, landed property in Singapore are mainly only applicable to Singaporeans, broadly speaking. So as a result, I believe if anyone try to do NFTs on landed properties, they are going to experience certain definitely some pushbacks from the relevant authorities. And also with regards to NFTs and coins or tokens, securitized tokens, we need to be very clear here. NFTs are not regulated in Singapore, but if you break them out into multiple coins of the same nature, you could potentially fall under the collective investment schemes, which is an regulated activity. Hence, the points need to be very clear. And to answer the question, the second part of the question, which is to in turn issue NFT to the investors at $10,000 per NFT token, that will most likely, in my view, go into collective investment schemes. Hence, once again, there could be pushbacks from regulatories on that at this juncture, especially in terms of the ABSDs, the and also some of these regulatory licensing required from MAS to do that in Singapore. So as of this juncture, we are definitely still looking into all these regulations, but at this juncture, I would say it's not outright illegal, but there will definitely be issues with regulatories on that, and that requires further discussions with the relevant authorities.
Yeah, indeed. Again, a very hard question to answer on the spot because there are many issues that you need to consider and many layers. Again, you know what does the NFT really represent? If it's a fractional interest in a landed property, then you would have issues because as TV mentioned, there are certain ownership restrictions related to landed properties. If it's a token giving you access to some kind of income, rental income, sale proceeds, then you really move towards the realm of securities regulations because this is becoming to look like an investment product. So you do need to consider the different permutations and implications. Yeah. So I hope that answers your question. We've been asked to start wrapping up this session. I hope that the session has been helpful for you. And I like to take this opportunity to really thank our panelists, Tiwi, Ian, and Sylvette. And I hope the audience, you have enjoyed today's session. If there's any help you need, please feel free to reach out to us. And we hope to see you again in our next event. Thank you very much.
Thank you, Li Ling, Sylvette, Ian, and Tiwi for that delightful exchange.